brief review of microeconomics and of law, particularly common law. And now we begin the substantive work on various areas in the law. If you're a lawyer and someone comes into you and they have a complaint and they are considering filing a case, you'll have to first of all decide what kind of case this is. Is this a dispute in property? Is this a dispute in contracts? Is this a dispute in torts? And the answer to that question will relate to great categories that you've formed in your brain. Because the thing about being a lawyer is you have to know a lot of facts. The facts have got to be well organized and accessible and analyzed in your mind. And the categories of law, property, contracts, and torts, the three areas that we discussed first, are three of the major categories into which you will have organized the cases and the statutes that you've learned over the years. So we have to start then with the great area of property law. And property law is a particularly great area because property is thought to be so important to the organization of society. Property conveys rights over things, it conveys responsibilities over things, and it distributes income and wealth in a society. So naturally, if it does all those things, if it conveys rights, if it conveys responsibilities, and it also distributes the wealth and power in a society, it's going to be a very important idea in the traditions of political philosophy, in political disputes and the like. Now, the beginning of this chapter has three quotes that I think are particularly nice for illustrating the three different aspects of property that I mentioned. The first is by William Blackstone. Originally, there was no common law taught in the universities. In Europe, the law in the 17th century, as it was taught in the universities, as it had been taught since the 13th century, was basically Roman law. The Code of Justinian and the arguments about that code. So law is a very ancient subject. It's much older than economics, by the way. Economics did not emerge as a subject until the 19th century. But law is a very ancient subject. However, the common law was not taught in the universities. The common law, the law that the English had worked out themselves through the courts, was not taught in the universities. And the first professor to do so was a person named William Blackstone, who organized the common law in a great book that he wrote called Commentaries on the Law of England. And in the Commentaries of the Law of England, which is in the second half of the 18th century, there's a quote about property that is very important. He says, "There is nothing which so generally strikes the imagination and engages the affections of mankind as the right of property, or that sole and despotic dominion which one man claims and exercises over the external things of the world in total exclusion of the right of any other individual in the universe." That's pretty strong language, isn't it? It's the sole and despotic dominion that a person exercises over external things in the world in total exclusion of everybody else. Now that's a statement of property as rights. It's a special kind of right, a kind of right that's referred to as a liberty. And the characteristic of a liberty is this. Characteristic of a liberty is that you can either do something or not do something. It's up to you. You can do something or not do something. Do or not do. It's up to you. It's your choice. And furthermore, your choice is protected. It's protected from the interference by anybody else. That anybody else could be another private person, or that anybody else could be the government. So in every system of private property, the owners have rights where they can choose to do or not to do, and those rights are protected by the law. What sort of things can they do? Well, here's a list of some things you can do with your property. You can possess it, use it, develop it, improve it, transform it, consume it, deplete it, destroy it, sell it, donate it, bequeath it, transfer it, mortgage it, lease it, loan, exclude others, etc. It's a long list of things you can do or not do. It's up to you. So private property creates a liberty, a zone of individual discretion, and it's absolutely essential to economic life that this exists. However, the definition of property as a right that Blackstone offers does not mention the responsibilities that go with property. The second quote here is from a guy named Max Gluckman, who was an early anthropologist, a legal anthropologist. He studied the customary law of Africa, particularly a tribe called the Barotse, who live in what subsequently became called Rhodesia. Now, in anthropology, when people talk about law, they don't necessarily mean the law of the state. Sometimes when people talk about law, they mean the law of the state. But there are societies that have no states, but yet had law. If you read Pospisil on the law of the Eskimo, you will be reading about a people who had a law and no state. If you read Pospisil on the law of the Kapauku, who live in Papua New Guinea, you'll also be reading about a people who had law and no state. Well, this book of Max Glucksman, called Ideas of Barotse Jurisprudence, is about the law of a people that existed independent of the state, because you see, law and social norms are intimately entwined, and they're entwined today. Some people think that the state is a vast bureaucratic mechanism and that it can operate and bring us legality simply through the civil service. And that is entirely false. Unless law aligns with social norms, unless the civil servants, the police, the judges, the bureaucrats and administrators enjoy the support of the people and of the citizens, law is helpless. Bureaucracies are helpless. You know, we have a schizophrenic view towards bureaucracy. Sometimes we think of bureaucracy as this massive machine of efficiency. So I felt that way. I don't know if you've ever gone to Navy Day and stood on the dock in San Francisco and looked up at one of those great aircraft carriers, and you look at that thing and you think, my word, this is the material embodiment of bureaucracy. How in the world is it possible for human beings to build and operate such a complex object? It's not the engineering accomplishments that's amazing, it's the organizational one. The fact that the whole darn thing can operate. Well, that's the power of bureaucracy. But of course, bureaucracy also does the stupidest things imaginable and paralyzes itself. They send an aircraft carrier to do the job that a rowboat could do. So, the interaction between social norms and the state is very important. Indeed, the origin of the common law is in the norms of the people. When William Blackstone called his book Commentaries on the Laws of England, he did not mean the enacted statutes by Parliament. He also meant the laws of England as they existed in the practices of people. The social norms that judges had taken up into the common law. and given the authority of the state. And that still goes on today. Because you see, when common law judges find a new legal precedent, when they change the law from the law of accidents from negligence to negligence with the defense of contributory negligence, as we saw in the Butterfield case, or when they change the law from negligence with the defense of contributory negligence to last clear chance, as we saw in the Davies case, when they do that, they're not just making it up. They're drawing it out of the social norms of people according to the sense that people have of what's fair and right. Otherwise, the judges would have no authority. So you see, with property, there are not just rights, there are also responsibilities. And in a tribal world like the Barotse, the responsibilities are particularly great. Think of it this way. Suppose you have property and you have 3 children, and you have to write a will. Well, on the one hand, in America, you're entitled to write up the will the way you want. If you live in a tribal world, probably you're not. Probably the division of your property is prescribed by custom and you can't change it. In America, you can. If you want to give all your property to one of your children, you can do it. In France, you can't do that. You can't give all of it to one. And in America, except in special circumstances, you ought not to give it all to one. You ought to do something else. Maybe divide it equally, or maybe equality is your rough starting point, and then you divide it somewhat unequally according to special needs. But that's what you ought to do, because owning property carries responsibilities. It doesn't just carry rights. In the Judeo-Christian tradition, we're supposed to give 10% of our wealth to others. Not many people do that today. It's amazing. We're much, much richer than our ancestors. And our ancestors very often gave 10% of their income away. They gave it to the church, which then took care of people. My father gave 10% of his income to the church, always. And he was poor. He was an orphan. A lot of people don't do that anymore. Now that we're rich, we don't feel like we have to give our money away. Well, you do. You have to if you want to be a decent person. If you're so darn rich, don't just vote for the poor. Figure out what they need and give it to them. That's your responsibility, because owning property is not just rights, it is your responsibility. However, it's also the case that in the American legal system, as with your will, so with the poor, you can choose. You can decide how much to give to the poor. The law won't make you, but that doesn't mean you don't have responsibility, because you do. So what Max Gluckman said about the Barotse is, in the African tribe called the Barotse, property law defines not so much the rights of persons over things as the obligations owed between persons in respect of things. Got that? It's not so much the rights of persons over things as the obligations owed between persons in respect of things. So if you're a father in the Barotse tribe or a mother in the Barotse tribe, you have to divide up your property. Your property has to be divided up when you die. I don't remember how the Barotse do it. Some tribes are matrilineal, some tribes are patrilineal. Can go a different way. In the Cherokees, a man worked the land that belonged to his maternal aunt. That's hard for us to get our minds around, but that's the way it worked. In lots of tribes, the land is divided up according to strict kinship, but the people who are in control of the land at any point in time have a responsibility to their descendants to make sure that they get that land in good shape, that it's taken care of properly, that it's not exploited and destroyed. So as a consequence, when Gluckman looked at the Barotse, he saw not rights so much as responsibilities for property owners. And the final quote is from Marx. Marx and Engels wrote a pamphlet called the Communist Manifesto. How many have read the Communist Manifesto? I don't know if you do that anymore. Oh, good. I'm glad if some people have read it. Okay, well, as you know, communism was one of the main philosophical movements of the previous century, of the 20th century. And in much of the 20th century, it was a militant movement that caused, in the name of which a lot of blood was shed. It's hard for us to recapture that spirit of commitment and belief, but in the 20th century there were many people who died for communism, and there were many people who were killed by communists. Now, in the Communist Manifesto, Marx and Engels summarize what communism is. It really is a wonderful quote. It says, "The theory of the communists may be summed up in a single sentence: abolition of private property." Some people think the communists were about equality. Marx wasn't so interested in equality as he was interested in getting rid of property. He thought private property was the root of all evil because it was the cause of all subordination. In his view, the state was, quote, the ruling committee, the executive committee of the ruling class. That is to say, politicians were simply put in place by people with money. That was his vision of the world. And that was everywhere. It was in every country, and it was between countries. Within country, it was the exploitation of the rich by the poor, and between countries, it was imperialism, the exploitation of the rich countries, the exploitation that the rich countries imposed on the poor countries. And he thought it would be fixed if you just got rid of property, so the communists tried to get rid of property. For example, they collectivized agriculture. They converted private ownership of farms in China and in Russia to collective farms, owned collectively, where the collective was a kind of quasi-state organization. And as a consequence, the collectivization of agriculture probably killed more people than all the wars in the Second World in the last century. The best estimates of the deaths in China in the winter of 58, 59, and 60 were about 20 million. It's unbelievable. 20 million people starved to death because of the collectivization of agriculture, because Marx thought that if you destroyed property, you would liberate people and you would free them. Fortunately, we don't have to go through that experience again to know it was wrong. He's wrong about that. Nevertheless, there is a relationship between exploitation, subordination, and property. No doubt about it. You do not have the power that Bill Gates has in the coming election. You do not have the influence that he has. And all over the world, there are people who have great wealth who have done very little to deserve it. Some of the richest people in the world are in the Middle East sitting on top of oil fields, and that's all they've done is sit. They're not creative people. So there's something to the fact that a good property system has got to distribute property properly in such a way that it leads to production and creativity. A good set of property rules leads to production and creativity, which is the basis of the wealth of a society. And the distribution of the property is arranged so that the creative people who make wealth get much of it. That's the way a property system works, which is successful. Now, I said to you property consists of rights, and those rights carry responsibilities. And there's also power attached to property, which can lead to creation or subordination, which can lead to wealth or exploitation. Now, what we're going to do in this class is we're going to analyze the consequences of having liberty over things. Property attaches things to people. And we're going to discuss the consequences of having liberty over things, the choice to do or not to do something with your property. And the list of things that you can do or not do with your property, I read some of them to you. There's a lot of things a property owner can do or not do. And we're going to analyze a few of those things in careful detail. And the core of our theory is going to be based upon the economic notion of a bargain. We're going to develop a bargain theory of property. So as a consequence, the first right, which concerns us, is the right to sell something. When you sell something, you have a choice. You can keep it or you can sell it. It's up to you. You don't have to sell it. That's an aspect of your liberty as a property owner. But you may sell it if you wish to. That's a part of the power of ownership. If you can't sell your property, it's not as valuable to you, it's not as useful to you as if you can sell it. So by having the right to sell your property, you have the capacity to do or not to do something that could be quite valuable and quite important. Now, when property is bought or sold, it usually passes from a person who values it less to a person who values it more. And it's the passage of the property from someone who values it less to someone who values it more that creates value. In the 18th and 19th century, people who thought about economists wondered, how can these people who buy and sell things create any wealth? After all they're doing is moving it from one person to another. So, for example, in the 18th century, there were people who thought that all the wealth really comes from some basic production activities, especially farming. It's the farmers who create wealth, and the people who then distribute the agricultural products. They don't create wealth because all they're doing is allocating what somebody else has already made. That's a lot like Marx's view that the workers produce everything of value, and the people who distribute and sell and manage the company don't produce anything of value. That was called the labor theory of value, very similar. Well, these people were confused over the fact, they didn't understand or appreciate fully, that when a good is sold, ordinarily the person who buys it values it more than the person who sold it. And that's the creation of something worthwhile. It's the creation of consumer surplus or utility by that transaction. Yes?
Under the same idea in the Christian tradition,
Yeah.
St. Augustine
Yeah.
had come up with the theory of the just price.
Yes.
And he said that only value can be added if someone adds something to that good in a physical way, or has to transport it through dangerous, some kind of transaction.
Yeah, well, that's right. There's a long tradition among religious people of thought about who actually creates value, who doesn't, and a lot of it is deeply confused. For example, Christians following Aristotle and Aquinas for years were against lending money on interest, as many Muslims are today. And the prohibition on lending money for business was a terrible handicap to the development of the economies. I mean, can you imagine how things would go in Silicon Valley today if you couldn't borrow money? Now, the Muslim view today is that Muslim view allows stocks but not bonds. It's to say you can participate in a business activity by buying stocks in the company, but you can't lend money to the company, buy a bond for interest. That's one understanding of the. I don't want to exaggerate. That's one understanding of the Islamic tradition. There's a lot of Muslims who don't agree with that. Okay, it all comes back from Aristotle. You know, the Christians got Aristotle from the Arabs because the Christians lost the text. That's awfully confused. I don't think we should start with that idea. Now, the idea of the just price is an interesting idea, and I'd be glad I could talk about that at length. I had a colleague here who wrote a book on the just price. Devout Catholic. It's a wonderful book. Turns out that most modern people who think about the just price for very long it turns out they conclude that the just price is almost always the market price. It's just sometimes it's not. Okay? Like maybe it's not just before the hurricane. Okay? All right, well, that's good. I appreciate that question, and I'm particularly glad that you're thinking about this, because if you've read Augustine, you've read something about the just price, you should think about it. You should be asking yourself, well, what is the relationship between the just price and the market price? All right, now, you all are familiar with the model of perfect competition, in which everybody is a price taker because there's so many buyers and sellers. And as a consequence, nobody bargains with anybody else because there's nothing to bargain about. But we're going to talk about a bargain theory of property that starts with exchange that takes place when there is a bargain, when there is scope for a bargain, when there's not perfect competition, and in order for there not to be perfect competition, we need a good which is somewhat unique. And so, on page 74, I have the following example. Adam, who lives in a small town, has a 1957 Chevrolet convertible in good repair. Now, a 1957 Chevrolet in good repair may not mean a lot to you, but it means something to me. And my generation is willing to pay for it. The pleasure of owning and driving the car is worth $3,000 to Adam. Blair has been coveting the car for years, and she inherits $5,000 and decides to try to buy the car from Adam. After inspecting the car, Blair decides that the pleasure of owning and driving the car is worth $4,000 to her. Got it? So we have Adam, who owns the car, and Adam finds that driving it is worth $3,000. And what we're going to call that, we're going to call that the use value of the car. It's the value of using the car. All right? Now, Blair inherits $5,000. So she's got $5,000. That's what she inherits. And she inspects the car and she asks, how much would its use value be to me? How much would I be willing to pay for it? She says, well, what I'd be willing to pay for it is up to $4,000. That's what the use value is to me. Right? So now we have a case where there's clearly a surplus that can be created if Adam sells the car to Blair. And the surplus is how much? $1,000, right? Because we transfer it from somebody who values the use of it for $3,000 to someone who values it for $4,000. It's like creating $1,000 in value. Even today, you'll find people confused about this. They'll say, what do the middlemen do? Cut out the middleman, he does nothing. No, the middleman does something important. He finds out people who value goods more than their owners. That's what he does. By doing that, he creates value. Okay, so we have a surplus then. Surplus of 1,000. And in order to realize that surplus, what we do is we have to get that car from A to B. And now they're going to bargain together. Now, when they start bargaining together, what we know is this. We know that Adam will not sell the car for less than $3,000 because that's how much he values driving it. And we know that Blair will not pay more than $4,000 because that's how much she values driving it. So what we know is the price has got to be in between, right? It's got to be in between $3,000 and $4,000. How much is it going to be? What's it going to be exactly? Well, economists have for years tried to find the, quote, rational solution to this bargaining game, and I'm not going to go through that history. What I want to say is this. What the price is actually going to be is going to be something that is determined by the skill of these people, they'll do a lot of misrepresentation, for example. For example, Blair will say, well, don't offer me less than $3,600 because I'd rather keep the car and drive it than have less than $3,600. That's not true. In fact, what she's willing to sell it for, the lowest price she'd be willing to sell it for is $3,000, not $3,600. But of course, Blair doesn't know how much Adam values it, and Blair's going to do the same thing. He's going to look in the cards. He's going to say, well, you know, this is a pretty nice car, but yeah, those tires, they're pretty bare. I'm going to have to buy new tires. That's $200 right there. So you say $3,600. Well, let's start out by taking $200 off that for the new tires I got to buy, and that's the way it goes. And maybe they succeed in reaching a deal. Usually they do. Usually, where a surplus can be had, a price will be found and the exchange will be made. Now, one area where we know this is true is courts. Because what we know is that people can almost always get a surplus by bargaining and settling out of court instead of litigating, because litigating is expensive. Whatever the outcome is that the court gives when in a dispute over money, whatever the money judgment is that the court gives, the parties could replicate that by a private agreement without all the transactions cost of the trial. So there's almost always a surplus to be had from settling out of court, and we know that in most classes of cases you get settlement rates of roughly 95%. So in court cases where there is a surplus to be had from settling and it's a money dispute, you're talking about a 95% success rate, a 5% failure rate. 5% failure rate, something goes wrong, somebody miscalculates. Adam thinks, well, what he values the car at is not $4,000. What he really values it at is $4,500. So as a consequence, Adam mistakes Blair's willingness to pay and demands too much, and the bargain fails. But that doesn't happen very often. So most of the time we're going to get an agreement. It's going to be in this range, and where's it going to be? Well, there is a theory about where it ought to be, which is that they ought to split the difference. That the price should be around $3,500. That way, each of them gets an equal share of the surplus. Each of them gets $500 from the surplus of $1,000. Now that can be fancied up in a model, and that's what something else that great man John Nash did, whom I mentioned to you. The guy from A Beautiful Mind. I told you he developed the notion of a Nash equilibrium, which I explained to you was a situation where nobody can do better by changing their strategy unless someone else changes their strategy. Right? As long as everybody else continues doing what they're doing, it's best for you to continue doing what you're doing. That was the notion of a Nash equilibrium. Nash's idea of a bargaining solution was that each party should get what's called his threat value. His threat value is what you can get on your own, without the cooperation of the other party. So, no, that's not right. Excuse me. Yeah, that is right. No, that is right. That's right. So, what Adam can get on his own is the use value of the car, which is $3,000, and what Blair can get on his own is to keep the $4,000 in cash, rather than paying $4,000 to Adam. If they don't cooperate, Adam drives the car, Blair keeps the cash. If they do cooperate, Blair gives Adam the cash, and Blair drives the car. So we have to look at what each person can get on his own. Now, if we think about what Adam can get on his own as including the full value of his inheritance, the $5,000, that he inherited, then we can say what he's got to work with is $5,000. He can keep the $5,000. That's his threat value. Or he can have $5,000 minus the price of the car plus the use value of the car. So he get that way of thinking. He has $5,000. He gives up however much he has to give up to buy the car, and he gets the use value. The use value for him we know is $4,000. So if he pays $3,500, then he ends up with $5,500. He gets $500 of the surplus. Now, this language may seem kind of silly to you. Threat value, the use value of the parties. Could even add some more language. We could talk about the cooperative value of the game, which is the sum of the payoffs to the two parties when they cooperate. We could talk about the non-cooperative value of the game, which is what they get when they don't cooperate, the sum of their threat points. Now, I told you that in this class you need to speak a foreign language. You need to learn a foreign language and speak it well, and this is the first example. You need to be able to speak this language. I'm telling you, this thing, students always want to know one thing above all else. Is it going to be on the exam? Yes, it's going to be on the exam. You've got to understand the bargaining model, you've got to master its terms, and you've got to be able to apply it in a variety of contexts. Now this value here, $3,500, which divides the surplus equally, we're going to call that a reasonable solution. It's reasonable because, you see, after each party gets its threat value, and then you split the surplus, neither really has much to complain about, right? I mean, why should one get more of the surplus than the other? It's a reasonable solution. And just knowing how to make that calculation is very valuable to you if you're a lawyer. This is not a language that most lawyers know. But I'm telling you, it's very valuable. I've been a consultant on quite a few legal cases. And one of the things that I always want to do in a complicated legal case is to figure out our threat value and the other side's threat value. Because once I figure out our threat value and the other side's threat value, then I see what the settlement offer is. And I can see whether it's reasonable or not. So, if this were a legal dispute, and I were representing Adam, and Blair was offering to settle, that is to pay, let's say it's a legal dispute over the ownership of the car, which is uncertain, and Blair offers to pay $3,300, then I say to my client, Adam, that's not reasonable. That's not reasonable. He's offering you $3,300. That means he's getting 70% of the surplus and giving you 30% of the surplus. That's not reasonable. And if you then explain it to the other party, you say, look, we're willing to settle for a reasonable amount, for an equal split of the surplus, but we're not willing to settle with you getting 70% of the surplus. So either you accept a reasonable offer or we're going to trial. Usually the other side will accept. You can explain that to them. On the other hand, if you're representing Adam and you find that Blair is offering you $3,700, offering you 70% of the surplus, then you say, thank you very much, we accept. Now, in a complicated case, it's sometimes hard to figure out what the threat value is, and you have the opportunity to do that, my friends, because on page 77, there's a box called a civil dispute as a bargaining game, and I want you all to solve the questions in that box. I want you to find the reasonable solution to this dispute between Arthur and Betty. You notice A and B tend to pop up a lot. Between Arthur and Betty over a broken pot. It's kind of a fun case. Did you know that if you're arguing in a court of law, you can argue contradictory defenses. Did you know that? Yeah, you can do that. That's what happens in this case. See, the facts are Arthur alleges that Betty borrowed a valuable kettle and broke it, so he sues to recover its value, which is $300. The facts are very confusing. Betty contends that she did not borrow a kettle from Arthur. She contends that even if he proves that she borrowed a kettle, it's not broken. It's another kettle that's broken. And she contends that even if he proves that she borrowed the kettle and it's broken, she didn't break it. Now these are three contradictory defenses, right? I mean, one of them can be true, but not all three of them can be true. Nevertheless, you can make such arguments. So, given the fact that you can make such arguments, it's not always best to make such arguments. I mean, sometimes you want to concentrate on only one, because if there's a jury, you want to be very clear and very simple. You don't want them to think in too complicated a way. For example, if you were to say, even if it is proved that the plaintiff borrowed a kettle, the defendant borrowed a kettle and broke it, I didn't break it. Well, you see, you might not want to make that argument, because then the other side then the jury might think, oh, well, he wouldn't have made that argument if he hadn't broken it. He's conceding something here. So trial is a strategic game. It's very complicated, and one of the results is there's a lot of confusion in the laws of blunt instrument. It often gets things wrong. And that's what this case shows you. This is a case where there's a 50% chance of the plaintiff winning because the facts are so confusing. And then the question is, what would be a reasonable settlement of the case? And that's what you've got to figure out. Any questions about that? Yeah.
Just on this function that you have over there on the side, the inheritance minus the price.
Yeah. Yeah.
What does that final answer lead? The final surplus?
Well, the point is that fair enough. It's a little confusing. I feel that I have to put it in. It's a little confusing. The point is that Betty inherits $5,000, and that gives her enough money to value the car at $4,000. I mean, before she inherited the money, she had some money, but she just didn't value it at more than $3,000 because she didn't have enough money. Now she's got $5,000. She's willing to pay more. She says, if I've got an additional $5,000, then having that car to drive would be worth $4,000 to me. So the point is that at the beginning, each one has some amount of wealth. Let's call it wealth 0. And then, if it's Blair's wealth, she gets another $5,000. And that changes her willingness to pay, so that now she's willing to pay $4,000. So what she's going to end up with is this. Either there's going to be no cooperation, in which case she gets her $5,000 plus her initial wealth. That's what she has. On the other hand, if there is an agreement, if she succeeds in agreeing to buy the car, then what she gets is the use value of the car, which is $4,000, minus the price that she pays. Right? So if the price that she pays is $3,500 and the use value is $4,000, she gains $500 from the transaction. That means that now her total dollar value of her well-being is W0 plus $5,500. Right? Yes?
So isn't value more of a social concept? And in that sense, isn't it arguing that correction of individual values, part of A and B, rather than creation of value?
Mm-hmm. Well, you'd agree with me that in the first class I discussed going from utils to dollars, right? Discuss the problem of how you get a demand curve, where a demand curve comes from. And I explained to you that one of the interpretations of the demand curve is willingness to pay. That's what it means. So I think that if Arthur is it Arthur? Adam. If Adam is willing to pay $3,000 to use the car, and Blair is willing to pay $4,000 to use the car, then it seems to me if the use is transferred from Adam to Blair, then you should have created $1,000 in value. Now, I'm not sure what you mean by social value, because it seems to me that refers to the value to Adam, and it refers to the value to Blair. That's Adam's utility and Blair's utility. Now, what you mean by social value, I'm not sure. I guess maybe what you mean by social value is the sum of those values.
Rather, like, value of any object is determinable by the society. For example, a diamond isn't actually that valuable, but it's only valuable in the society. So, in this instance, since they're both individuals in that society and have different experiences, their valuation of a car is going to be different just on that basis. But can you say that you're actually creating value, as rather than not correcting their own individual beliefs of value?
Yes. Well, first of all, the question you raise is a very old one. You know, there's a dispute, ancient argument about why diamonds are more valuable than water. A pound of diamonds is worth a lot more than a pound of water. The question is why? Because water is a necessity. And this seemed to puzzle people in the 19th century. It doesn't seem to puzzle people today, because when we draw a demand and a supply curve, we immediately get the answer. The diamonds are a lot more valuable than water, because diamonds are very costly to produce. And people who have some money are willing to pay a lot for them. Whereas water is relatively abundant, and therefore relatively cheap to produce. And once people have met their necessary needs in water, they don't value it that much more at the margin. So the problem was dissolved once we got supply and demand theory. So this is it's an old problem that you're discussing, and I think the point is this: whenever we talk about how much people are willing to pay for a good, we're holding constant a lot of things. Now, one of the things we're holding constant, the most important thing that we're holding constant for purposes of economics, is how much money they have. Because we know that how much you're willing to pay for something depends upon how much you have to spend. So when you draw that demand curve, you're holding constant the income of the parties and varying the price of the good. And that's, as economists say, other things being equal. That's one of the things that's being held constant. One of the things that's equal, it's not changing, is the income of the parties. Now, there are deeper things as well, which is the preferences of the parties. It may be that Blair likes that 57 Chevy so much because of some social experiences that she's had, and if she'd been subjected to advertising by Ford instead of General Motors, maybe she would not value this car so much and would prefer a Ford. That's another thing we're holding constant. As economists say, we're holding preferences constant. Okay? But I think that the questions you raise are good questions, but I also think economists have very good reasons for doing it the way we do. Yes? Mm-hmm. Mm-hmm. Well, that's a very good point. One of the things that I did not do in this analysis is discuss the transactions cost of the bargain itself. Because the bargain itself usually takes time and effort. Sometimes it actually takes money. I didn't discuss that because economists have an order in which we simplify things. And the way we usually simplify things, if we're talking about a transaction, is we'll start out by assuming there aren't transactions costs of the usual kind. They're not transactions costs in calling up the other party and talking to the other party and taking time off from work to go out to the house and inspect the car. We assume all that away. Okay? Yeah. Okay, well, I got to move on because what I want to tell you is that the bargain theory, this bargain theory that I've given to you here, this is actually applicable not just to used cars, but at the highest level of philosophical abstraction. So, for example, if you've taken a class in constitutional law, in legal studies, or you've taken a class in political philosophy, you may have discussed contractarianism. Has anybody encountered this term in another class, contractarianism? Nobody? Nobody has read a word of John Locke? Who's read John Locke? Well, a few people have read John Locke. But didn't you read the second treatise on civil government and learn about the contractarian theory of the state? Maybe you did, but it's not organized in your mind that way. The point is this. The founders of the United States and many other people since the 18th century have often thought of the creation of the state as a kind of implicit contract among people. What happens is people are living in this state of nature. And in the state of nature, they do a lot of things that they ought not to do, such as stealing from each other. And that means they have to spend a lot of time defending their property. And that means that in the state of nature, people tend to be poor. The philosopher Hobbes' term was life in the state of nature is nasty, brutish, and short. He said it was nasty, brutish, and short. And if you live in the Sudan, you understand what he's talking about. Sudan is a place where the state is failed or in disarray. And life is nasty, brutish, and short for an awful lot of people. And the philosophers of the 18th century who created our government imagined our Constitution as a contract that people had implicitly drawn up so that they would have a government in which they could have liberty. They could enjoy their liberty and they could prosper and pursue happiness. And this was a wonderful change from the previous conception, which was that the state was something created by God and given to the king. The state was something that the king owned by right from God. That's a very different view from the view that the state is something that the citizens created by a free contract among themselves in order to secure their liberty and their prosperity. So this was a huge improvement. And the structure, the logical structure of contractarianism is much like this bargain. Except that the threat position is now called the state of nature. The threat position is what you get when you can't agree on a state and you have to live in nature, nasty, brutish, and short. And the Constitution itself, the creation of the government, that is the bargain solution. So the contract theory, this little theory of the bargain is just remarkably powerful. It can apply to used cars or it can apply to the U.S. Constitution's philosophical foundation. That's really something. Now, in the book, I discuss the application to the creation of civil society with some numbers in which people raise corn and they steal corn from each other and they defend against the theft of their corn from others. And then they decide that what they ought to do is create a state and put an end to all this thievery and spend less on defense, and they'll both be better off. And then they divide the surplus. And that I'm not going to go over because now I'm going to go to something else. I'm going to use the bargain theory and apply the bargain theory to the proposition, which is the most remarkable proposition, most discussed in law and economics, called the Coase theorem. Ronald Coase is an economist at the University of Chicago. He's 101. Still alive, not by much. I was there to celebrate his 100th birthday, but we had to celebrate on his 99th year because we didn't think he was going to make it to 100. He fooled us, but it's not the first time. All right. Now, I'm sure that some of you have driven on Route 5 up from Sacramento into Oregon. And as you are getting near the border, you come to one of the most gorgeous sites in California, and that is Mount Shasta. Mount Shasta, what a gorgeous site. You know, we have this wonderful row of volcanoes. They're wonderful as long as they remain dormant. And when you fly up the coast, you look out the airplane to the east, and you can see them in a line. And Mount Shasta is one of the highest and most beautiful. It always makes me think of Mount Olympus, because when I drive past it, as I do time to time, my grandson lives up there, it's usually covered with clouds. You know, Mount Olympus was usually covered with clouds because the gods didn't like people peeping at them. And I always think that there must be gods living up there. It's so gorgeous. Well, anyway, Mount Shasta is in the middle of Shasta County, and Shasta County is an old county in terms of law, because Shasta County is a county where you still have the conflict between the ranchers and the farmers. Now, you kids didn't grow up on westerns. You grew up on outer space, but I grew up on westerns. And there used to be songs like, "Oh, the rancher and the farmer should be friends." Yes, the rancher and the farmer should be friends, because they were big enemies. And the reason they were big enemies is because the farmers wanted to keep the cattle out of their crops, and the ranchers wanted the free range. And as it turns out, we have two different sets of laws in the United States. One is the law of the open range, and the other is the law of the closed range. And the open range, we can refer to that as ranchers' rights. And we can refer to the closed range as farmers' rights. And in Shasta County, there are parts of the county that are open range and parts of the county that are closed range. And they're still fighting over whether to close more of the range, because the process, the progress, some would say, of economic development inevitably leads to less ranching and more farming, including in Shasta County. So there's still pressure to close some of the range. Now, for a long time, people thought about laws such as open range versus closed range, and they asked themselves, what difference will it make? For example, what difference will it make to the placement of a fence? And the Coase theorem found a completely counterintuitive answer, that everybody had been reasoning wrong for a long, long time. So let's see what that is. Suppose that here, this is all in the book, of course. Suppose that this is a ranch. And down here, there's a farm. No, I think I draw it like this. There's a farm, and part of the land is tilled. This part of the land is tilled. Right? It's got crops on it. Now, you might think to yourself as this: if the law is open range, that means that the rancher does not have to fence the cows in. The farmer has to fence the cows out. Because if the rancher's cows get into the crops and eat them, the rancher is not liable. He doesn't have to pay money. Because it was up to the farmer to fence the cows out. So if the cows got in, the fault was with the farmer. No liability for the rancher. And the opposite is true if the rule is closed range. If the rule is closed range and the cows get into the farmer's crop and eat the farmer's crop, then the rancher is liable because the range is closed. It was the rancher's responsibility to keep the cows in. So under open range, the farmer has to fence the cows out. Under closed range, the rancher has to fence the cows in. Now, given those two legal regimes, you might think that the placement of the fence is going to make a big difference. It's going to be determined by the law. You might say to yourself, if the rule of law is open range, then the farmer is going to have to build a fence like that to keep the cows out. And you might say, if the rule of law is closed range, then the rancher is going to have to build a fence like that and fence the cows in. Right? Now, the question is whether you're smarter than a couple hundred years of lawyers thinking about this problem. Can anybody see why that reasoning is flawed? Yes? Exactly. Because this is a long fence. And this might be a shorter fence. And if this is a shorter fence, it's cheaper to put the fence around the crops and fence the cows out than to put the fence around the ranch and fence the cows in. Right? Okay, so suppose that the law is closed range. So the rancher has the responsibility to fence the cows in. But you're saying he's not going to do it. What's he going to do? Exactly. He may call up the farmer and say, look, it's true, I'm obligated to keep the cows out of your crops. I'm liable, and if they're not fenced, my liability is going to be more than the cost of the fence. Those cows can do a lot of destruction. So I got to keep the cows out of your fence, but it's going to be a lot cheaper if I pay you to build a fence around your fields than if I have to put the fence all the way around the boundary of my property. And what should the farmer say? Should the farmer say, yeah, great, let's do it? Now, what should the farmer say? This guy has obviously read the text. Okay, you want to jump in? Go ahead. Yeah, I should say, wait a minute. I don't just want the cost. I want half the surplus. So if it costs, I can't remember the numbers in the book. If this fence costs 100 and this fence costs 75, then the farmer says, I don't want just 75. I want 75 plus half the surplus. Half the surplus is the difference in the cost of the fence here and the fence here, so the difference is 25. I want half of that. So give me 75, my cost plus 12 and a half, and you got a deal. That's what he should do. That's the reasonable bargaining solution. So what Coe said is, doesn't matter what the law is. Doesn't matter whether it's open range or closed range, from the point of view of placing the fence, because the fence is always going to be placed in the most efficient position. Well, if the fence is going to be built here anyway, why is it that the ranchers and the farmers get so upset when the law is going to be changed? When the law is going to be changed from open range to closed range, all the ranchers turn out at the county meeting and there's a lot of bad feeling. Angry speeches are made. I know this because there was a property lawyer at Stanford named Bob Ellickson who went up to Shasta County and studied it. I didn't choose Shasta County by accident. I chose it because there's a whole book on cows and cattle in Shasta County. So I know what happens when they're going to close part of the range from this proposal, which is they have a big emotional meeting. Why should there be an emotional meeting if they're going to end up putting the fence in the same place anyway? Yes? Well, the responsibility of who has to build the fence changes, and let's cross out responsibility and write in another word, and you got it exactly right. It's the cost, right? It's a matter of who's going to bear the cost and who's going to get the surplus. So the point is that under closed range, the rancher has to pay 75 plus 12 and a half. Under open range, the rancher doesn't have to pay anything. Is it any wonder they disagree? So the point is this. The Coase theorem says that if the parties can bargain together, there's no problem of inefficiency. The efficient thing will be done. The fence will be put in the cheapest place. There is, however, an effect on distribution. Because who bears the cost and who enjoys the gain, the surplus, is going to be different according to what the background law is. This was a stunning discovery. Absolutely stunning discovery. And it's still discussed today. If you go to law school and you go to if you go to law school where you're not just preparing for the bar, but you go to a higher level law school where they're trying to give you a more general education, this will come up. Now, it's easy to get confused about what this Coase theorem is, and I'm going to tell you how to think about it so you don't get confused. In order for the rancher and the farmer to behave according to the Coase theorem, to do what's efficient, what's necessary is they have to be able to bargain together successfully, right? They have to be able to bargain together successfully. Because when they bargain together, what they should do, if they're rational, is maximize the joint value that their activities create and distribute it between them, just as Adam and Blair did. To maximize the joint value between them, they needed to transfer the use of the car from Adam to Blair. And then they would maximize the joint value between them, and the price at which the car was sold would distribute the surplus between them. That's what you do. What you do is you maximize joint value and distribute the surplus through the price. If you're not maximizing joint value, you're throwing money away. Something's wrong. You're not bargaining properly. Now, in order to see the truth of the Coase theorem, think about this. Suppose that Miss R married Mr. F. Miss R married Mr. F. Well, if Miss R married Mr. F, and they combined the operations of the ranch and the farm, they assuredly wouldn't care at all what the law was with respect to the placement of the fence. They put the fence in the most efficient place. Regardless of what the law is, it's not as if Miss R and Mr. F are going to sue each other if they're happily married. Right? So, if they were to marry and merge the two activities, that's like they'd be maximizing joint value. That's what they'd be trying to do. And they wouldn't care about the law. They'd ignore the law. And what the bargain theory says is you don't have to be married to do that. You just have to be rational bargainers. If you're rational bargainers, you don't have to marry each other. You just have to not throw money away. If you don't throw money away, then you'll reach the most efficient solution with respect to the location of the fence, and you'll divide the surplus between you in a reasonable way, and you'll go out to those meetings and you'll argue over whether the law should be open range or closed range, which is exactly what we observe. So the Coase theorem then is a proposition that people who bargain together can act like people who marry each other in the sense of maximizing joint value regardless of the structure of the law. Now, one of the characteristics of the Coase paper, the problem of social cost, which is what I date the beginning of modern law and economics from, published in 1960 in the Journal of Legal one of the characteristics of this paper, which makes it a great classic, is that he never states what this theorem is. He talks about ranchers and cows, and he talks about other examples too. Another example is this. In the 19th century, railroad trains emitted a lot of sparks. In the early 19th century, they mostly burned wood. Later on, they burned coal. But either way, they emitted sparks. And because they emitted sparks, the sparks sometimes set the fields on fire among farmers. So, Coase asked this question. The rule of liability could be that the railroad has to pay for the destruction that sparks cause when they're emitted, or it could be that the railroad doesn't have to pay and the farmer has to absorb the loss. What difference will it make to the crops that are planted and where they're placed? For example, if you're concerned about your crops being burned, then you should plant close to the railroad tracks cabbage and not corn. Cabbage doesn't burn very well. Corn, I'm sorry, I'm using corn in the English sense as wheat. Wheat burns much easier. So if you plant cabbages rather than wheat by the tracks, there'll be less destruction from sparks setting the fields on fire. What difference will it make whether the rule of law is liability of the railroad or liability of the farmer? What difference will it make to whether you get cabbages or wheat planted next to the railroad track? Coase said, make no difference at all, because they should bargain together and maximize the joint value. It is going to make a difference to the rental value of the property and to the profits of the railroad. It's going to make a difference because it's going to affect who has to pay. Just like here, it affected whether the ranching activity was more or less profitable than the farming activity, depending on who had to pay. Same thing. But it's not going to make any difference to what's efficient if they can bargain together. So Coase has a series of examples like this. And he doesn't actually state what his theorem is. Well, that turns out to be a brilliant strategy. If you're Ronald Coase, you can write such a great paper as this, because that means that there's going to be 25 years of people arguing over what Coase really meant. I used to be the editor of a journal, and I returned many manuscripts saying, I do not publish papers anymore on what Coase really meant. That reaches diminishing returns pretty quickly. But there is a kind of agreement about what the theorem says. And what the theorem says is this. The structure of the law doesn't matter from the point of view of efficiency if there are no transactions costs of bargaining. That's the key. No transactions costs of bargaining. Transactions cost is a very important term that Coase did not invent, but he revitalized it in this paper and another paper on the corporation. So he said if there's no transactions cost, then people will bargain together to efficiency. And he rolled into transactions cost just about everything that would prevent the bargain from occurring. Okay? He had in mind not only, let's go back to the car example. Suppose that Blair had to take time off from work to come and look at the car. That's a transactions cost. If that were high enough, there would be no transaction. For sure, if it were over $1,000, it would be irrational for him to come and look at the car. So, Coase had in mind that all costs of that kind, the cost of a telephone call, the cost of time, the opportunity costs that are used up in transacting, all of that would have to be zero in order to assure that the legal entitlement went to the party who valued it the most. The legal entitlement is going to end up with the party who values it the most if there's no transactions costs that obstruct the bargain. He also put into transactions costs strategic games that the parties might play that would cause them to fail to agree. And this is a brilliant simplification. It's absolutely great. Someday, if you go on and study this subject more, you'll understand that the Coase theorem permits you not to do game theory, and you would always like to avoid game theory if you can, because the results are indeterminate so often and difficult. This is really easy. You simply treat everything that goes into obstructing that bargain as a kind of cost. And you call it a transactions cost, and then you say, with zero transactions cost, you're going to get the efficient allocation of legal entitlements regardless of the underlying rule of law. And that's where we stop today.